this debate about whether or not the justices at the Supreme Court the number of justices at the Supreme Court should be capped, comes up every now and then. In fact, recently when the president nominated some 4 justices for the Supreme Court, questions were asked about why we need more justices at the Supreme Court. But what does the Constitution say? And making reference to what happens in the United States, can that also reflect in our local situation, especially because we derive the inspiration from the Constitution of the United States and the British as well? I have one person who lives the Constitution. She served both at the global and continental level and for the Republic of Ghana as Chief Justice. Sophia Akuffo is my guest. Thank you so much for agreeing to speak to us today.
My pleasure.
Before we get into the substantive question about capping of the number of judges at the Supreme Court, what is the role of the Supreme Court in our justice delivery system as a country?
The first one, which most people are aware of, is that it's the final court of appeal, which means that a case may start in the magistrate court and go through the ranks all the way through, and from the Court of Appeals, there's another opportunity for appeal, and that is to the Supreme Court. But beyond that, the Supreme Court also has what we call original jurisdiction. Original jurisdiction in the enforcement of the Constitution and the interpretation of the Constitution. The normal, ordinary human rights provisions of the Constitution, those can originate, if you want to enforce it, you can originate the enforcement of your right, your personal right in the High Court. But if you want to enforce it, not necessarily because you have been harmed, but you feel that something that is going on and is being allowed to go on is harmful to the general populace, you could actually bring it to the Supreme Court. And if that's the first time, it will be interpreted and enforced there. If it has already been interpreted before, then it becomes part of our general law. So then you enforce it, you start it in the High Court or even in the Circuit Court, if it depends.
So even though it's the final court of appeal, can the Supreme Court review its own decisions, as in rule in a matter, but if I, as a person, feels that, look, I still have a case, I can still have the Supreme Court review its own decision?
Yes, under the Constitution, the Supreme Court has the power to review its own decisions. But to bring an end to things, it defines the parameters within which it will exercise that jurisdiction. The review is not intended to be a second appeal in the Supreme Court. No. You have only one chance of appealing to the Supreme Court. But if you feel, if you think, or if you believe that there was a very important fact they seem to have completely missed, and because they missed it, injustice has been done to you, you can bring the application. But then they will look very critically at it. Or maybe a certain law was not applied and it ought to have been applied. Or you've come across a certain piece of evidence which all the time you didn't even know it even existed, and you had no idea at all. So review is not something that is granted very often. It's few and far between. Yes.
But can the review, if granted, lead to a change in the earlier ruling
Oh, yes. Oh, yes. After all, that's why the person wants the review. They want the decision to change. And if it is a justified review or a justified application, yes, it will change the decision.
What are the essential characteristics of the Supreme Court in fulfilling the role that you have just talked about?
It's the final court, or the essential characteristics for it to be able to do what it does. Yes, it has to be credible. It has to be effective. In fact, justice at any and every level has to be credible. It has to be effective. Credible in the sense that all things being equal, if you lost, you will feel yes, the facts didn't, or the law didn't favor you, and that's it. It shouldn't be that, and if you want to appeal, the appeal normally should be because you believe that your facts were not properly taken into account, or the law was not properly applied. So it's the facts and the law. If these two are handled properly, professionally, and as they are supposed to be, that's what we train as lawyers, and eventually you become a judge, and to be able to analyze facts and apply the law to it. And so appeals do not always, just because you've appealed doesn't mean you will win. Because sometimes the fact that you think the judge did not comprehend or did not take into account will be so minuscule that even if it is now taken into account, you still lose. So you can as an old judge once said, you can the court can be right and it can be wrong, and that's why there is a right of appeal. But there has to be also an end to litigation. That's why it's decided that this is the final court. So in Ghana, in terms of appeals at the Superior Court, you've got 2 bites at the cherry.
Right.
Yes.
I see.
And then the review is another kind of opportunity, but it's not an appeal, as I've said. Yes.
And if at the apex courts, what we've seen over the period is the question about the impartiality or the independence of the
Exactly.
itself.
Exactly.
How in the discharge of their duties are they able to prove beyond reasonable doubt that there is independence and there's impartiality?
Who's proving? The judge?
Yes.
It's not the judge's job to prove that they are independent or impartial, but that is how you do the job. It's a quality. It is a sine qua non. It is assumed. It's one of those things that should be assumed, because how do you get credibility? How can you be a credible judge if it cannot be, your independence is questionable? But you see, judicial independence is both internal and external. Internal in the sense that you're not taking sides. You've read this one, you've read and listened to this party, and you've read and listened to that other party, you've listened to the witnesses, you've done your research, you've looked at all the applicable laws, and you put it together to come to a conclusion as to who is right and who's wrong, because we do have an adversarial mode of arriving at our judicial conclusions. So primarily, you're not there to mediate between the parties. You're just going to decide this one is in the right and this one is in the wrong. This one wins and this one does not win. And to mitigate that, that is why for almost about 20 years now, the judiciary or the administration of justice has been adjusted in such a way that at the trial stage, you're given an opportunity to have the matter mediated. So you win some, you lose some. You owe me 10 million cedis, but if you will, if you will pay me 8 million today, I'll just drop it because I have taken other things into account. But that's at the trial stage. But strictly speaking, throughout litigation, all the way, the parties can always agree to mediate their dispute and settle it and announce their settlement to the court. In fact, there was once a case in the Supreme Court where we were ready with our judgment, and then the lawyer for one of the parties said he has been discussing the matter with the other lawyer, and they would like to be given the opportunity to settle it amicably. So we gave them, I think, 3 or 4 months. And they came back, and we were very happy with the outcome they had come with, because it was as it should be. It had to do with a community. And so they could now continue to be a community rather than disputants, and one lost and one won and one laughed at the other, and it leads to more fighting. Yes.
You see, every time there's issue about and I asked about the independence and impartiality of the Supreme Court for specific reasons, because not too long ago, with certain high-profile cases, that question always comes up as to how impartial or independent the judiciary is. If all the justices at the Supreme Court are giving the liberty of having their own opinion based on their own reading of a particular case, and so they can dissent and not necessarily rule all 9 judges in a particular direction, 7-0, 9-0. The likes of the National Security Minister and others, governance experts, think that it sends a certain signal, raises questions about the independence of the Supreme Court justices.
You see, unfortunately, that is perception. That's not necessarily what is or what was. Because just because 9 people, there were 9 judges, right? Yeah, just because 9 people came to the same conclusion does not make it a doubtful outcome. If it's a bad case, it's a bad case. If it's a good case, it is a good case. There are some cases that are so awful and baseless, and all the judges can agree. Sometimes they can agree for different reasons, but they will all arrive at the same conclusion. Other times, the matter speaks so much for itself that after having judgment conference, because that's part of the process, the behind the scenes process, the panel meets, and each one then talks about what they think should be the outcome and for what reasons, and so on and so forth. And sometimes it is so glaringly good or glaringly bad that they'll decide, okay, one person should write the opinion, but each one of them can write their opinion. And we've had cases whereby all 9 will all write their opinion, but for different reasons. Or they may agree on certain aspects, but their reasoning for arriving at a certain aspect of the issues may be different, but equally valid. That is also judicial independence, to agree with your colleagues as to how you arrive at Adan, or whether you will go through Somanya, or you would prefer to go through Akuffo and wander around and round and round, or go directly. That's everybody's right. So the fact that there have been a series of cases, and the Supreme Court has been ad idem. The judges have agreed with each other. Yeah, it happens all the time. There's nothing wrong with it.
Because you talked about perception, to what extent does that take some level of consideration in the Supreme Court dealings, so that people's experiences with the Supreme Court, or any, not just the Supreme Court, but the judiciary, is what is captured in surveys conducted by the likes of IEA, capturing people's experiences with the different arms of government, and in this case, the judiciary. So would you disregard the experiences of the people that captured in these surveys as against what your experiences are about? You see, now I'm a former judge. I could be lecturing, I could be training, I could be actually doing surveys and so on and so forth. But when we come to what a judge sitting on that bench over that case is expected to do, they are so expected to apply the law to the facts, as they have understood the facts. And you see, that's why they would, even at the Supreme Court and at the Court of Appeals, they also do. Because when it's a multi-judge panel, you always do meet to discuss. Because sometimes you've got this angle, but you didn't quite catch that angle. And you get a more holistic picture. Because the group dynamics works positively when you do that. And but to arrive at your conclusion, you can't say, fellows, in the last case when we did this and that, and we all agreed, the people were upset. So this one, let's let it go this way. Or, okay, two of you disagree, and the rest agree. No, that cannot be. That is not how it's supposed to be. Now, that is why, you see, of the people who are interviewed or surveyed, I would like to know how many of them bothered to read the judgment. It's not therefore I will grant, or therefore I refuse. That is the conclusion. How was it arrived at? It's the reasoning, the judicial reasoning in arriving at the decision. That is also crucial. Yes, it can run into 30 pages. I've seen, well, not in Ghana, but on other panels, courts I've sat on, somebody's opinion, one opinion, being over 100 pages. Yeah. Did you read it? Before you would say you agree or you don't agree. You have to read it. You must. What constitutes the quality of justice? And this is something I know you've been very passionate about. I followed your presentations at The Hague. You still hammer on quality justice. What's the details of that?
Quality justice, in a nutshell, would be characterized by, well, as I mentioned, credibility and effectiveness. But credibility in itself would be fed by how knowledgeable the judge is. You know, that one you would call it competence. How competent the judge is. That's very important. Competent, firstly, there's a basic competent, know your law. Yes, it doesn't, these days we all agree, doesn't all reside in the bosom of the judge. That's why certainly throughout the Commonwealth, continuing judicial education is harped on all the time. And they go back to the classroom and be taught about trends and what is happening in other jurisdictions and new enactments, complicated enactments. You take them through provision by provision and so on and so forth. So it's competence. It is also independence. Independence is as I said, it's sine qua non. You cannot have justice. The word justice itself is not even just a common word. It's even I would say it's a religious word. It's a biblical word. Yes, it is just. It is as it should be. Yes. So that's why independence and integrity. You cannot be independent and lack integrity. And if you lack integrity, you cannot be independent. So that they go together. And then efficiency. You know, sometimes the delays in the whole thing from the commencement and through on and on and on and on and on and on, that can give an impression that they're up to no good. Or I won, but by that time the money was worth nothing to me, therefore I did not get justice. A litigant can say that. Yes. So efficiency is important. Efficiency is also partly personal to the judge, and to a very large extent also your workspace. How efficient are your